Dear colleagues and friends, a warm welcome to all of you to the Netherlands Institute at Athens. My name is Jan-Paul Krielaert. I'm the director of the Institute since March 1st of this year. Although archaeology is a core business of the Netherlands Institute at Athens, it wishes to accommodate Greece and Greek-related research in a broad sense, so not strictly focusing on antiquity. This year, the Netherlands Institute celebrates its 50th anniversary, as you can also see at the screen. And this is a good occasion to look back and look at the future. One observation that we can make is that Byzantine studies have become solidly embedded in the range of scientific fields covered by NIA. This counts especially for Byzantine law, and an important boost has been given with the donation of the book collection of Professor Spiros Troianos. Next week, on 12 March, 6 o'clock, there will be Byzantine talks at NIA dedicated to the memory of Professor Troianos, and you're all cordially invited to join this meeting. Details you can find on the website of NIA. But back to this evening. I'm extremely happy that we have here tonight a very special double book presentation of two extremely important works in the field of Byzantine law. One is a companion to Byzantine law, edited by Professor Emerita Eleftheria Papagianni of the National and Kapodistrian University of Athens, and Dr. Daphne Penna, who is affiliated with the universities of Groningen and Leuven. The other is the monograph Byzantine Law, the Roman Law of the Eastern Roman Empire, published by Cambridge University Press and written by Daphne Penna. Both scholars have given us the honor to be present here, present their work, and engage with us, with the audience, in a conversation. The Troianos Library is in the very capable hands of Mrs. Sotiria Nikolou, the librarian of the NIA. She is also the organizer and the moderator of tonight's event, and it's a pleasure now to give the floor to her to further introduce the topic and the speakers.
Hello from me as well. Thank you all for being here, both in person and online. We're very happy that in the framework of the NIA Library's activities, we have this double book presentation today. It was included in the library's plans to organize a book presentation related to Byzantium, as our director said before, since the generous donation by the late Professor Spiros Troianos, a new sector on Byzantine studies in the NIA Library was created. So we are very pleased that Dr. Eleftheria Papagianni and Dr. Daphne Penna accepted our invitation in order to make this plan come true today. And I would like to warmly thank both of them for being here with us tonight. And at this point, I would like to thank my colleagues from the Netherlands Institute at Athens for their quiet support and for making this event possible. Our director, Professor Dr. Jan-Paul Krielaert, our deputy director, Willem Lederboer, Emi Makri Mestropian, Panayoti Gasparato, Yanni Makri, Galina Yadzenko, Anna Pefani, and Yanni Dimopoulo. Before I give the floor to our today's speakers, I would like to shortly introduce them to you. Eleftheria Papagianni served as Professor of History of Law at the National Kapodistrian University of Athens Law School, where she taught History of Law and Byzantine Law. She retired on the 31st of August in 2024. Since 1981, she has participated in the International Research Project for the Republication of Byzantine Legal Sources of the Keteken Academy of Science based in Frankfurt am. She served as director of the project from 2008 until 2011, and since then until its completion by the end of 2022 as member of its steering committee. She is the author of many books and articles, mainly on Byzantine civil law. Daphne Penna is Assistant Professor of Legal History at the University of Groningen and Associate Professor of Roman Law at the Catholic University of Leuven. She's the author of the Byzantine Imperial Acts to Venice, Pisa, and Genoa, if I'm saying that correctly, on 10th and 12th centuries, and comparative legal study, and co-author of a source book on Byzantine law, illustrating Byzantine law through the sources. Penna's interest lies in Roman and Byzantine law, and especially in their influence on the European legal tradition. She has published extensively on this area, almost 50 publications. So, Daphne, now the floor is yours.
Yay. Ladies and gentlemen, thank you for being here today with us. There are some seats in front if you would like. Yeah. And first of all, we also would like to thank the Netherlands Institute, Professor Papagianni and I, for this invitation. It's a pleasure to be here. And I think you might think a double presentation, book presentation, how long will it last? I think I will give an outline so you know what comes, right? Today we will present, where's the outline? Here. So the outline of the event, we present two books. The first book is a companion. That's, the main presentation because it's also the bigger book. And we will begin with, Professor Papagianni will begin with an introduction about this companion. She will speak about the aims and purposes of this book, the making of the companion, which lasted many, many years. You'll hear about that later on. And then, together with Professor Papagianni, we will present the chapters and the authors of this book. And then, after that, I will give a very brief presentation about the second book, which is a smaller book. So don't worry about that. It will not take too long. And then we will open the floor to discussion and engage with you, as the director said. We were very happy to engage to you in the discussion. Also, I know that several authors will be online, and we are delighted about this. So I give the floor now to Professor Papagianni for the companion.
Thank you very much. Thank you for the invitation. I'm very glad to be here. And I promise also that it won't take too long. Many years ago, in 2011, the publishing house Brill, on the recommendation of my dear colleague Wolfram Brandes, proposed to me to coordinate the publication of a book on Byzantine law within the framework of the companion series. After accepting this proposal, early discussions focused on how to approach the subject. Would the object of research be the rules of substantive law as they were formed after Anno Domini 330, when historical developments brought Roman law into contact with Hellenistic legal tradition and Christian teaching, or the texts handed down from the past and adapted to the new conditions, as well as the new legislation produced by the Christian emperors of the Romans, who were now based in Constantinople. The second approach was chosen because research on categorizing Byzantine law into persons, things, and actions remains unclear, making a concise overview unreliable, especially for such a book, a companion. Meanwhile, since the mid-20th century, scholars have increasingly focused on studying and producing reliable critical editions of legal sources as understanding. Byzantine substantive law depends on reconstructing accurate texts and analyzing their relationships. The starting point for the writing of the companion would therefore be the Byzantine legal texts, which would also be examined as mirrors of the historical and social developments of the period. The question of the chronological scope of the research, that is, whether it would cover all the centuries for which the term Byzantium can be used, that is, from the foundation of Constantinople in 330 until his fall in 1453, was the subject of more discussion. As to the starting point, both the future editor as the then representatives of Brill agreed that the year 330 was appropriated as starting point for presenting the evolutionary course of Byzantine law from its Roman foundation to its transformation into the reformed law of the Eastern Empire. By contrast, there was no immediate consensus as to the end point. Finally, after 1453 was rejected, since it was considered to require a great expansion of the field of research, which was deemed incompatible with the companion, 1056 was preferred, that is, the end of the Macedonian Dynasty's rule. This rather unconventional choice was made on the basis that from 330 to 1056, the transformation of the law inherited from the Rome into linguistically Hellenized law, which had adopted elements from the Hellenistic tradition and had been influenced by the Christian religion, can be defined. This process is characterized by the constant codification and recoding of provisions beginning in the 5th century with the Codex Theodosianus and ending with the completion of the Basilica. The Justinianic Corpus Juris Civilis certainly occupies a central position both as the concluding phase in the development of Roman law with the Code and the Digest, and as the starting point for the new law through the hermeneutic teachings of the antecessores in the Justinian area and the Justinianic novels. At the same time, the innovations in the legislation of the 8th century, the ecclesiastical law, and the most important jurisprudential evidence of the period are presented in this companion. After the framework of the research and the way of approaching the test had been defined, a multinational group of authors was formed. However, for reasons unrelated to the editor or the authors, the project was frozen for years, and it was not only early 2021 that a systematic effort to his completion began, 10 years after the beginning. Of course, the writing team could not be the same. In addition to those who, for various serious reasons, were not willing to be involved in the project anymore, some of our dear colleagues, as Ruth Makridis, Peter Piller, Konstantin Pitsakis, had already passed away, and from the initial team remained active only Thomas van Bohove, Kelly Burdara, Wolfram Brandes, Fausto Goria, Andreas Goutsukostas, Dieter Simon, and Spiros Troianos. Therefore, the writing team had to be enriched with more contributors. In fact, these changes meant a new beginning for the project because, apart from the effort to find new authors, those who had sent texts in the initial phase of the project had to be informed about the developments in order to update or possibly revise them. It was precisely at this crucial stage that the publisher proposed the involvement of a co-editor. The proposal was accepted with great pleasure by me, who chose for this role my old student and dear friend, Dr. Daphne Penna, assistant professor at the University of Groningen, and in the meantime, also associated professor in the Catholic University of Leuven, without whose participation, as I have already written, and I repeat now in public, it is doubtful that we would have a complete work available today. The book begins with an introduction consisting of 3 preliminary contributions about the origins of Byzantine law, some of his aspects, and the history of the scientific research on this material. Furthermore, it is divided in 3 parts where the material is exposed in chronological order. Every part is initiated with an overview and the presented period followed by the highlights of his legal production, included aspects of canon law. To the convenience of the reader, the book is closed with an index of legal sources. And then?
So we have Professor Papagianni finished with the introduction on the making of the companion, the purpose, aims, and history of it. And now we will move on to presenting every chapter and author. We have divided the authors by the chronological. I mean, the older generation will be presented by Professor Papagianni and the younger by me. So we thought it's a bit, just that you think, why? So, okay. As Professor Papagianni said, it's structured in 3 parts, right? There's first the introduction, then part 1, part 2, part 3. So we begin with the introduction. There are 3 chapters there. So the first chapter was written by, it is entitled "The Birth of Byzantine Law." It is written by Zachary Chitwood, Professor of Byzantine Studies at the Ludwig Maximilian University of Munich, and this chapter outlines the main characteristics of Byzantine law, clarifies how Byzantine law is defined, examines the periods of Byzantine law, and reflects on future research directions and approaches in the study of the Byzantine legal tradition. The second chapter, Eleftheria.
Yes, this chapter from Spiros Troianos, who was professor of legal history at the University of Athens from 1971 to 2000, and one of the most renowned legal historians and distinguished Byzantinists, who donated also his library to the Institute, is about the creation of a parallel legal order, the canon law. This chapter is about how the Roman Empire became a Christian empire in which the church and the state became more and more connected. Daphne.
Chapter 3 is about the history of research on Byzantine law, written by Marios Dandalos, who's present here today, and is working at the University of Athens here. And it's about, the chapter is intended to give a brief sketch of the history of research, of course, of Byzantine law. It enumerates the most prominent scholars of the field and the intellectual endeavors of the academic centers devoted to the study of Byzantine law. And now there's many of the authors are now the younger generation, so I'll stick to, so you only have to look at me right now. We continue to part 1 of the book, so from Constantine the Great up to Justinian's death. Chapter 4, entitled Byzantine Law from Constantine the Great to the Death of Justinian, an Overview. As Professor Papagianni said, every time there's an overview being done in every part. This chapter has been written by Vasilios Alexandros Kolias, a researcher at the Research Center for the History of Greek Law of the Academy of Athens, who, by the way, will be talking next Tuesday here at the Byzantine Talk in memory of Troianos. Chapter 5, that's the entitled Codification of the Leges, written by Kalliopi Papakonstantinou, Associate Professor of Legal History at the Aristotle University of Thessaloniki. It is about the making of the two codices, which codified the imperial legislation. That's the code by Theodosian in 438, and the code by Justinian. Chapter 6, it's entitled Codification of the Use. We move to the codification of the writings of the Roman jurists. The digest is that part of Justinian's legislation, which is written by Giuseppe Falcone, professor of Roman law at the University of Palermo and of Roman legal science at the Corso di Alta Formazione in Diritto Romano of the University of Roma La Sapienza. In just 3 years, ladies and gentlemen, Justinian produced, from 530 to 533, Justinian produced the digest, a grandiose, to use an Italian word, codification of legal material coming from classical jurists' works. This chapter examines the making of the digest, which had a very big, great influence on European private law. Chapter 7 is about another part of Justinian's legislation, the institutes, written by Professor Kalliopi Papagostadinu, as he has written. That's the second chapter she wrote in this volume. The Institutes of Justinian was a legal textbook that became also a law. Chapter 8, about the novels of Justinian, written by Peter Saris, a professor of late antique, medieval, and Byzantine studies at the University of Cambridge. A great connoisseur of the novels, who has translated them in English as well. The chapter discusses the significance of Justinian's novels, their place within the codification program, their text, transmission, the reflection of their reflection on the reign of Justinian, and their modern reception, editions and translations of this work. Chapter 9 is written, by myself. It's about law teaching at the time of Justinian. It was really nice writing this chapter, I have to say, because it goes back to the research and writing that's been done in the University of Groningen on the work of the antecessors, the law professors at the time of Justinian. So it deals, this chapter, with legal education under Justinian, focusing on the curriculum based on his legislation, the methods of the antecessores, the law professors at the time of Justinian, and their legacy. Chapter 10. And now we are in the part 2, so we move now from Justinian's death up to Basil I. The first chapter, which is an overview, is written by Valerio Massimo Minale, Associate Professor of Roman Law at the Department of Law of the Federico II University of Naples. And then chapter 11.
It's my turn now. So you saw how many changes were made because, and how many dear colleagues could not participate. So chapter 11 is from Wolfram Brothers, Emeritus Professor of Medieval History, with speciality in Byzantium at the Goethe University in Frankfurt. And it is a chapter about the canons of the Quinis Sextum or Trullanum, the synod, the ecumenical synod in Trullo, in the realm with Trullo in Constantinople, which are fundamental of Orthodox canon law. An extensive bibliography of most of the canons and their content is presented. The second chapter, 11, is about the Isaurian Ecloga, read at chapter 12, written by Fautos Togoria, Emeritus Professor of Roman Law at the University of Turin, and is about the Ecloga, which is a legal compilation issued in 741 and based in extenso on Justinian's law. It reorganized legal rules and penalties and introduced several particular innovations with respect to the Roman tradition. Chapter 13, again Fausto Goria, about from the appendix ecloge to the eklogation. So what occurred next to ecloga? This chapter surveys Byzantine legal sources between the ecloga and the Macedonian codifications, noting especially new developments in rules of marriage, divorce, crimes, and punishments. And now we are coming to part 3, the law at the time of Macedonian Dynasty. Chapter 14 is the overview, as always, written by Emerita Professor Kelly Burdara, a professor of the History of Law at the National and Kapodistrian University of Athens, in the law school. This chapter is, as its title implies, an overview of the Byzantine legal sources at the time of the Macedonian dynasty. Chapter 15, the Prochiros Nomos and the Isagoge. Thomas van Bochobe is the writer of this chapter, researcher of Byzantine law at the Department of Legal History, Faculty of Law, University of Groningen. The chapter discusses the Prochiron and its Isagoge as Macedonian legal handbooks, focusing on their content, transmission, status, dating, debates and authorship issues, as well as related legal compilation and scholarly discussions. 16. The novels of Leo VI the Wise. Again, from Kelly Burdara, the chapter discusses the 113 novels of Leo VI the Wise, highlighting scholarly debates about their origin, composition, and their wide-ranging legal content, especially in ecclesiastical matters, reflecting a concern for justice and equity. 17. The Great Codification, the Basilica cum Scholiis, and their immediate precursors. Again, for Thomas van Bochowe, the chapter examines the Basilica and their scholia and discusses key issues such its edition, its sources, compilation, structure, status, and the distinction between old and new Basilica scholia. Chapter 18, the Court of Hippodrome, from Andreas Gougiou Kostas, professor of Byzantine history and institutions at the Aristotle University of Thessaloniki, and is about the judicial institutions located in the covered hippodrome, focusing on the relationship between the Crite and the Drugarios of the Vigla and the nature of the so-called cart of hippodrome. 19. The Pira. Dieter Simon, Emeritus Professor of Civil Law and Roman Law at the Goethe University of Frankfurt, Emeritus Scientific Member of the Max Planck Institute and Director of the Max Planck Institute of European Legal History, and former President of the Akademie der Wissenschaften, der Brandenburgische Akademie der Wissenschaften zu Berlin. Dieter Simon, one of the most significant scholars of Byzantine law, examines in this chapter the Pira, which dates from the 11th century and consists of verdicts, opinions, and proposals for court judgments by Eustathios Romeos, a high court judge and probably the most important jurist and judge of this time.
Chapter 20 is entitled Legal Education in Constantinople in the 11th Century, the School of Laws and the Guardian of the Laws. It's written by Alexander Liarmakopoulos, Assistant Professor of Byzantine Law at the Aristotle University of Thessaloniki. And the chapter discusses the re-establishment of the law school in the 11th century Constantinople under Constantine IX and the appointment of Ioannis Xyphilinos as director of this law school.
And chapter 21, the Endymusa Synod, again from Spiros Troianos. So after the 1054 schism, the Constantinopolitan Endymusa Synod became the highest ecclesiastical authority in the East, gradually taking on a permanent role with legislative powers through issuing decisions known as tomi. Troianos examines the Endymusa Synod in this final chapter of the volume. This contribution of the late Spiros Troianos, professor at the University of Athens, is not only the final one in the companion to Byzantine law, but also the last publication of our first and common beloved teacher, who, although he was the first to send his contributions, passed away in January 2024 without having seen them published. Therefore, and of course in remembrance of his great achievements in the research of Byzantine law, the editors respectfully and lovingly dedicate the book to him. I would also like to remark that despite the misfortunes and losses also of Professor Jan Lokin in 2022, which caused a considerable delay to the publication of the companion to Byzantine law, the fact is that a group of scholars has still been assembled and has produced some remarkable text on Byzantine law and its sources. It is irrefutable proof that the discipline is always alive and kicking and always a source of interest for new scholars. This reality is certainly the work of the European legal historians who, after the Second World War, bent again over the almost forgotten law of the Eastern Roman Empire, some of whom have taken part in the successive phases of this textbook. Even those who ultimately failed to produce a text are, after all, delivering their scholarly legacy here to their students. Thank you very much.
Okay, we have finished the presentation of the companion, but I also wanted to say a few words about that. First of all, as you realize, it's the first time that so many scholars got together and wrote a book on Byzantine law. That's the most important fact of this, that makes this book very important. I also want to thank Professor Papagianni for inviting me to be the co-editor. It was tricky. It was let's say it was a dirty job, but somebody got to do it. But I have to say that when you co-edit something, and I have to say, despite all the problems that we had, because as Professor Papagianni described, at some point the project began again, so you have to see which version is there and what has been updated, and I'll spare you the details. But if you have a co-editor, it can also be some fun. So I think we also had some fun in the end. So here's a tip: if you ever want to edit a collective volume, get a reliable and fun co-editor, to have some fun as well. Am I right?
Yes.
Okay. We ended with the photos from the symposium organized by the NIA on the occasion of the donation of Professor Spiros Troianos' Byzantine book collection. There was a symposium that was organized here. We have very nice memories of this, and we were very happy that Troianos lived and saw this. And the second book that I will present very briefly is related somehow to the Netherlands Institute, and I wanted to mention this. After the death of Professor Troianos, the Netherlands Institute initiated an annual lecture series in memories of Professor Troianos entitled The Byzantine Talks NIA, focusing on Byzantine law, history, and culture. And next week we will have the third Byzantine law talk. The first Byzantine law talk was given by myself, and I was honored by the NIA to give this talk, and it was about Byzantine law and the European legal tradition. This was in 2024. The second book that I'm presenting here, and it's very different from the companion. It's actually based on that lecture, or one part of it. After that, a year after, I got an invitation from Cambridge University Press to make a short book, because the second book is very short. I don't know if you know this series Elements at Cambridge University Press. The idea is to present a very short book on a subject. When I say short, it should be 50 pages, which should be also introductory, written in a accessible language, let's say. It's easier said than being done, I can tell you. Try to write 50 pages is more difficult than writing 100 pages, as you know. So, and for me, the editors who asked me to write this book also said that I have to take into account or try to reconsider some basic issues of Byzantine law. So I thought about the lecture of the NIA. And the second part, because I'll come to the contents in a minute, is basically focused for a big part on the lecture of the NIA. This little book, as I write in the purpose of the element, it's called Elements. This is an element on Byzantine law. The purpose of this element is, as I write in the preface, is to make my husband's life easier. Because very often we are on social gatherings and they ask him, okay, what does Daphne do? So he's trying, I watch him sweat his way through trying to explain what Byzantine law is. And so I thought it's high time, to make a book to make the life of my husband easier. It's dedicated also to my husband and my children. But also for other people, to make a book that's very accessible on Byzantine law. Okay, here's the structure. It consists of two parts, a first part and a second part. The first part refers to basic questions of Byzantine law. What is Byzantine law? Why is Justinian important for the genesis of Byzantine law? How important the language was? You already see from the titles that it's written in an easy way to understand, right? Also the question of state law and canon law, of course, in Byzantium, the application of Byzantine law, and whether Byzantine law ends. It doesn't. Spoiler alert. In the second section, and I'll say very few words about that, is the one that I try to place Byzantine law in a broader perspective and compare it to the Western legal tradition, and part of it is based on the NIA lecture of 2024. Byzantine law and the European legal tradition, or Byzantine law and the Western legal tradition, is it a tale of two laws? Well, it is a tale of two laws, you could say, but both laws have something in common. Both traditions have something in common, and that is Roman law. Roman law, as it was codified by Justinian, the emperor in the 6th century. Both traditions, and in the West and in the East, are based on Roman law. And I explain this, and I explain it in the book in detail. Well, not in detail, as much as I explain it in any case. That in the West there's a kind of a gap of Roman law between the 6th and 11th centuries, which means that the codification of Justinian was forgotten, especially the digest, which the digest was the most important work. Whereas in the East, in the Byzantium, in the Byzantine sphere, the digest was never forgotten, or better said, Roman law was never forgotten. There's a continuity of Roman law. So both traditions, Western legal tradition, Eastern legal tradition, are based on Roman law, but there are also differences. And what I find problematic, and that's the criticism that I bring in this book in reconsidering Byzantine law, is that there are rare or non-existent references to Byzantine law in modern books of history of European law. And I refer, of course, to English editions, right? Not Greek. Greeks will also have something about Byzantine law, but I refer to English publications, which are the ones that are broadly read. And that's a bit unfair somehow. I explain this in the book, not only because it was a Byzantine emperor who gave us the codification of Roman law, Justinian, but also because there's a continuation in Byzantium. And whereas for the West, there have been many, many studies being made on the annotations, the glosse on Justinian's codification, and here's what you see on the left-hand side. In the center, it's a part of Justinian's legislation, the digest or the codex, and around it you see all these comments which are made by later scholars, 12th, 13th, 14th century, etc. These have been studied in detail by modern scholars, the Western glosse or annotations, but there are also glosse in Byzantium. I mean, there are also scholia, there are also annotations being made on the same text in Greek, on the Corpus Juris, on Justinian's legislation, and these scholia are practically not known or neglected, or Western scholars don't know about them. There are very few scholars that actually deal with these scholia, and it's a pity because they both have the same base. So it makes sense to compare them.
Daphne, Greca non leguntur.
Greca non leguntur. Okay, but also for us, a responsibility then, the people who know some Greek, to, you know, compare with the West or try to find some paths of collaboration. So that's what I'm trying to focus, that's what I try to highlight in this book. Why compare both traditions? Number one, if you do it, it helps to get rid of misunderstandings concerning Byzantium. There are still a few people who considered Byzantium something decadent, theocratic. That was not the case. So I give some examples of this comparison. And the second, it can help us to reveal the common legal heritage of Europe. And again, in the book, you can see some examples. Another way of studying Byzantine law and comparing it to the West is by placing some Byzantine legal texts in a broader perspective, meaning seeing how these Byzantine legal sources were transmitted in the West. And that's something that I do in 2.6, from Armenopoulos to Winscheid and beyond. That's about the Exabiblos, which is a law book from the 14th century, and I examine the tradition or the transmission, well, not in detail because of course it's a small book, but the impact this Exabiblos had in the West. And I come with some, not only me, I also base this a lot on Professor Pitsakis' findings. And there are some rather surprising elements there. I referred this also to the lecture last time in the NIA. The French novelist Racine refers to the Exabiblos, which is not so known and first discovered by Pitsakis, and I'm trying to get this through also in French-speaking public. I was in Leuven, well, also Dutch, but the French-speaking were looking at me like, ha! So you can see the links that you can make. And I end with a Desideratum, the book. Nowadays, there's really no dialogue between scholars who study the Western legal tradition and scholars who study the Byzantine legal tradition, with very few exceptions. I argue that it's worth studying Europe's common legal roots and examining how the Western and the Eastern parts of Europe are united in terms of legal history. Perhaps there are more elements that unite Europe than divide it, also in the field of law, and perhaps Byzantine law can play a catalytic role here. The study of Byzantine law is also study of European law. That's something that most historians forget. And more generally, the study of Byzantium is not only the history of the Eastern Roman Empire, but is also the study of European history. To conclude, I hope that this small book can convince the readers that Byzantine law, the law of the Eastern Roman Empire, can be studied in many ways and for many reasons. Thank you.
Thank you very much, both of you. And we're glad, Daphne, that we help with the book.
Yes.
So if anyone has questions, okay. But I would like to kindly ask you to keep it only in English, not Greek.
Thank you very much for your very interesting presentation of two very necessary volumes in English-speaking scholarship. I am not far from being an expert in Byzantine law or any kind of field related to law. I was just intrigued by what you said regarding the gap of Byzantine law in Western Europe between the 6th and the 11th century. So I was wondering whether this is a gap of sources or whether it is a gap of legal practices, because in Iberia at the time we have Isidore of Seville, and then we consider that there is a sort of dark age that has befallen after the invasions from northwestern Europe. But I was thinking whether this sort of gap relates to actual sources that are available to us now, or whether it is a gap of actual legal practices taking place at the time for which there is no sources. And I'm also thinking of the loss of hundreds, probably of thousands of manuscripts in the 1820s when the monasteries in Iberia were being privatized or closed as monastic institutions. So they lost the libraries that they had, some of which had manuscripts for a millennium by then. So I was wondering how much of that is based on the lack of manuscripts or other sources that survive to this day, and how much this statement is based on lack of knowledge of the legal practices that were taking place at the time, because part of the Roman heritage is actually to be seen in Latin American countries to this day even. So I was wondering on what kind of absence of evidence you base this statement.
Yes, thank you for your question. I had to simplify, as I told you. When I say there's a gap of Roman law in the West, I mean that you have the legislation of Justinian in the 6th century, which consists of the Codex, the Digest, the Institutes, and the Novels. And the Digest, as we explained, is very important because it codifies Roman law. This means that it consists of fragments of the best opinions of the Roman jurists who had lived in the 2nd and 3rd century. It's a big book. It's one law. It's, to give you an idea, it's 1.5 times the Bible. And it encapsulates the best of the Roman jurisprudence. It's like a legal encyclopedia. For a jurist, even now, it's a kind of paradise. You know, you'll find any solution, let's say, to a legal problem. I'm exaggerating a bit to make it better to the people who are not jurists. But so this digest, so the legislation of Justinian was not used from the 6th to the 11th century in the West. Yes, there was always some of Roman law, also in the West. The Codex, to be honest, was never really forgotten. I say this in the book. I just didn't have the time here to exceed. But Roman law was not completely forgotten, but we speak between the 6th and 11th century in the West. We speak mostly, we call this vulgar law because of it was not so sophisticated. The digest was missing, let's say, and suddenly, at the end of the 11th, beginning of the 12th, they rediscovered the digest, started to use it, started writing these annotations around the text, which are called glossae, and that's why the name, the glossators, the school of the glossators. And that's why, to go back, because you said Roman law is the base in Latin America, not only there, of course, in Europe, but it's due to this rediscovery that took place in Bologna, in Italy, at the end of the 11th, beginning of the 12th century. That's the story in the West. And this explains why Roman law is still the base of all civil codes. Mm-hmm. Even beyond Europe, Japan's code is based on Roman law as far as property law is concerned and law of obligations. In the East, in Byzantium, there's not a gap. There's always, in the 6th century, law professors produced very sophisticated texts on teaching this legislation, and this continued. Sometimes not always in the best way, but it was always there. That's what I was trying to say. Mm-hmm. But you're right, and in the book it's a bit more elaborate. What I have, and on the PowerPoint was a bit simple because I didn't have much time.
Thank you.
Yeah.
Any other question?
Maybe we should check the chat
Yes,
as
so-
well.
Thank you very much for presenting these books today. Actually, I do not have a question. It's just I would like to congratulate you both as editors of the first volume and as author of the second volume, because it is exactly this kind of works that are very much needed, I think, in order to make Byzantine law accessible, interesting, and more well known to a public wider than the few specialists that dwell in the field. So I think it was an excellent choice, both of making a companion, and I can only imagine how much work you have put, all of you and the authors, in making something that is condensed to the point, updated with the latest bibliographical research, and interesting. And I think it's a great contribution, as well as the short book on Byzantine law. It was exactly very much needed because many times, not only your husband, but all of us have to kind of explain what it is and why it is relevant, why it is important, even to colleagues in legal historians from other countries. It's like if it's, an old forgotten kind of kingdom who had gotten since Gibbon very much bad press, and which we're still trying to reverse. You know that even now in modern Greek, they use this expression Byzantinist to denote something that is intrigue or corrupt, and which is absolutely unacceptable. And I think we have to fight it. And this is, and both of these volumes, I think, will have a lot to make more well known the great contribution of Byzantium in preserving the Roman legal tradition, in making it its own, in going further, and in basically preserving what was the basis for all the modern law that we have and we still use to this day. So thank you very, very much for this great volumes. Thank you.
Thank you. Thank you.
Does anyone have any question? Because at the chat we don't have any question. They just congratulate both of you for the very nice presentation. Okay, we don't have another question. So now we would like to thank everyone for being here in person and online. And we want to invite people that are in the room to come upstairs for a drink. And we wait all of you next week at 6 for the visiting lecture. Thank you.
Thank you.
Thank you very much.